Hey, welcome back to the Law and Crime Network. I am Vincent Hill. We've been listening to the closing arguments in the Daniel Tate murder case. This is a murder on the beach in Wisconsin. The victim, Olivia McKay. Daniel Tate is on trial right now for that murder. The allegation is that he choked, drowned, and killed her, and then the defendant in this case and the co-defendant moved her body and discarded of her body at a later time. Joining me right now, defense attorney David D Pietro via Fort Lauderdale, Florida. David, how are you, sir?
Hey, thanks for having me. I'm well.
Always a pleasure to have you on, sir. We've been listening to closing arguments here, and of course, the prosecution just did their rebuttal in this case. But I want to talk from a defense standpoint for just a second here. The defense in this case is basically saying that the defendant, Daniel Tate, is not big enough to have done this, especially by himself. Of course, her body was moved. It was put in the trunk of her car. It was moved quite some distance from where prosecutors believe she was actually killed. But is that in itself a good defense? I mean, because honestly, to strangle someone or to choke someone doesn't take a lot of pressure, and it definitely doesn't take an extraordinarily large person. What do you think?
I think it's a good point that was brought out, but not one that's going to seal the deal at the end of the day. I think some of the better points that were brought out is the involvement of the state's star witness, and was that person really saving their own hide? Right. I think that's the evidence that could get the jury most convinced of a potential reasonable doubt.
Yeah, absolutely. And the one thing that strikes me really odd about this case is the co-defendant in this case, who's not charged in Olivia's murder, by the way, only charged of discarding of her corpse and stealing the vehicle. His print was actually on one of the bags. We've heard testimony about these trash bags. You can see the co-defendant there in this case, Jamari Cook. We've heard testimony about these trash bags, but Daniel's DNA, his fingerprints were not on these bags. It's actually the co-defendant. So I wonder how that's going to weigh on the jury to say, well, what was his real involvement? Was he involved with actually killing Olivia as well and discarding her body? What do you think?
Yeah, well, the state could end up having two people charged with discarding of a body, and no one convicted of murder. I mean, looking at Jamari's big individual, so that goes to the theory that it required somebody to be of larger size to commit and fulfill the totality of this crime. So interesting intertwining of theories that could play out.
Yeah, so the prosecution in their rebuttal, he basically said that Daniel would have had to have been the most unlucky guy in the world. I mean, if you look at it from a circumstantial point, everything adds up. The text message to his girlfriend, I'm going to go steal a car or two. I intend to steal a car, right? So then the car that Olivia owned was stolen after her death. We know that. And all pun intended, in this case, the glove fit. They found gloves via a search warrant at his residence where he was sleeping, and those gloves actually fit. So from a circumstantial standpoint, I think everything fits here. But is it enough to convict Daniel Tate of the murder of Olivia McKay?
So I thought the prosecution's rebuttal was very strong and passionate. Very good prosecutor. And I think that just that, lightning striking so many times, that's good stuff. I mean, right. I think jurors can hang on to that and understand that from a reasonable standpoint. So I thought both lawyers did a very nice job. I think that the prosecutor had more of a passionate side to him, and I thought he did a very nice rebuttal.
Yeah, and I think the prosecution left the jury with a lot to think about as this gets ready to go into deliberation. We are going to take a quick break. We will be right back. Stay with us. You don't want to miss it. Hey, thank you, Anthony, for that report. We greatly appreciate all that you do here at the Law and Crime Network. Still with me, David D Pietro. And David, yesterday I think we were all shocked by the shooting down there in Maryland. I mean, here we are again dealing with the mass shooting. But one of the first things I thought about when I saw where the target was and the type of business that they were in, I didn't think terrorism. Now, this is just me from my old police days. I didn't think terrorism. I thought it was either a former employee or someone that had a vendetta against that institution. And it comes to we find out now that it was 38-year-old Gerard Ramos, who apparently sued this organization, this news organization, several years ago for defamation. Yeah, I think the biggest issue here is, again, we see all of the signs that led up to this. There were the Facebook posts, the social media posts about this organization. They were pretty profane in what he was saying about this organization. So I think there were some red flags here, as in many shootings that we see, mass shootings that we see, that we could have prevented this. Unfortunately, a lot of people don't take these social media things as serious as we should. What say you?
Yeah, I think this one's a little different than Parkland, which is down in my area. I think those signs were more evident. Mm-hmm. I think this was a scuffle and a lawsuit. So sometimes it's hard to take vitriolic, responses on social media and turn them into potential mass shootings. This one is just so random, and it's becoming all too common. It's really bizarre, and I don't know what law enforcement can really do other than make appropriate security measures. But this is the first time we've seen it. All started with the comments of going postal, right? It started with the post, and now it's kind of gone to schools, and now it's going to newspapers. I represent the folks that were killed at the Fort Lauderdale airport, and it seems like people do this they're vigilantes and they want to make a big statement on the way out of their lives or ending their freedom. It's sad and tragic.
Yeah, it's definitely sad. And to your point, you're absolutely right. Law enforcement, we all know, can't look at every Facebook post, right? And let's be honest, people are what I call Facebook bravery. They're on steroids on Facebook because they know that, oh, I can hide behind a keyboard, I can say this. It doesn't really mean anything. But I think as we start seeing more of these mass shootings, especially when there is a social media account linked to the suspect, I think we're going to start seeing, and it's going to affect a lot of people because, quite frankly, it is our freedom to say whatever we want on our social media account. But I think it's going to start affecting a lot of people because I think we will have that scrutiny. We will start to see law enforcement looking at everything like that in the near future. What do you think?
Yeah, I think people are going to start to be more vigilant about noticing abnormal behavior online, aggression, anger, threats, and report those. And I think law enforcement is going to take them serious now, because if they don't, and then something happens, they're going to get blamed. So I think it's a public awareness situation, and people are pretty free to put their mental thoughts online, which is good, valuable evidence for law enforcement and should be used. And I think we're getting there as a society.
Yeah, and I always say there's always at least one or two people that knows the shooter's intentions, so we always have to, it's an old saying and it's cliche, we hear it a lot. If you see something, say something. If you hear something, say something. We have to get to that in this society. We're going to switch gears. We're actually going to get back to our discussion about the Wisconsin murder trial. This was a murder on the beach. Olivia McKay was killed, and the defendant in this case, Daniel Tate, is on trial right now for her murder. We're going to take a listen and go back to the prosecution's opening statements. Take a listen. Hey, welcome back to the Law and Crime Network. You just heard part of the opening statements from the prosecution in this case. Again, Daniel Tate is on murder right now in Wisconsin for the murder of Olivia McKay. Still with me is David D Pietro. David, what did you think? I know you're a former prosecutor, currently a defense attorney. What did you think of these opening statements? Do you think he presented his case?
Yeah, I think he's doing a very nice job of presenting a circumstantial case. And I think he's tying everything together piece by piece. And of course, the defense is going to try to unweave every single allegation as coincidental. But I think the prosecutor is doing a very fine job. And it looks, if I were to guess, it looks like it's more leaning towards conviction than not.
But you did say one very interesting word, circumstantial case. And, we heard during the rebuttal, during the closing arguments, the prosecution saying he would have had to have been the most unlucky guy in the world because of everything that led up to it that day, the text messages, the gloves, the mention of stealing a car, meeting her at the beach, and she was killed at the beach. But again, you did say the magic word, circumstantial. We want to hear more of the opening statements from the prosecution. Now, of course, there's a big piece of this that the car was involved in that, so we want to listen to that and see what the prosecution has to say in their opening statement. For him to say, oh, I didn't think anything was wrong, I just walked away, I was listening to music, there's still a part of me as an old investigator that says maybe Jamari Cook's involvement in this case is more than what he's saying.
Definitely. But I guess at some point, law enforcement and the prosecutors said they needed to prove this case through some sort of direct testimony. And they decided, for whatever reason, that who the most culpable party was and allowed the other one to testify. So those are decisions made by law enforcement for whatever reason based upon the value of the evidence if they think both people are guilty and what the truth is and where the truth lies.
Well, as cops, we always say we go where the evidence leads us during an investigation. We follow the evidence. We don't follow speculation or circumstantial stuff. We follow the evidence. So I think that's probably why we are where we are right now. So we want to take a listen to some cross-examination. Again, Jamari Cook is the prosecution's star witness, if you will, in this case. But let's listen to some cross-examination by the defense. Hey, welcome back to the Law&Crime Network. We just heard cross-examination of the prosecution's star witness, Jamari Cook. Still with me is D Pietro. And David, let's get right to it. I mean, this defense attorney made some pretty interesting statements here because according to police reports, what Jamari told the investigators, if she got up, they would both go to jail. So the defense is trying to say that maybe there is more involvement by Jamari because he didn't intervene to help because she could have been a witness against him. And I think maybe there's more she could have been a witness to than just this stolen car that Daniel Tate had text that he was going to do. Again, there's a part of me that says maybe both of these guys were involved in Olivia's murder. What say you?
So I guess the point I brought up a little bit earlier is an interesting potential outcome. Maybe the prosecution gets 2 convictions for the disposing of a dead body, or the jury thinks that both of them did it, and they end up coming back with a conviction of murder, and they have no ability for Jamari to convict him of murder. So it can cut both ways. But I tend to agree with you. It seems like both individuals were involved, and Jamari was involved more than leads the eye. But
how do we get to that point where Jamari is charged and convicted of her murder? Right now, he's not on trial for her murder. He's simply on trial for moving her body and, I believe, stealing her car. So wouldn't we have to do an entirely different trial, call in different witnesses, have a brand new jury if that was the case?
Well, if the prosecutors subpoena Jamari or force them to testify, he might have immunity at this point. He might not be prosecuted. He might have some sort of derivative source immunity, and They can't prosecute him. So that they might be stuck with what they got.
Yeah, he could have very well signed a proffer before this. We don't know, of course. That's not information that is privy too many times to the public. We want to do a little bit of a switching gears here. We actually want to talk to or listen to testimony from some of the ex-girlfriends of Daniel Tate. Now, remember, the prosecution introduced these ex-girlfriends who said Daniel Tate liked to choke women during sex. So first, we want to hear from the defendant's ex-girlfriend, Samantha Whittaker. Let's take a listen. Hey, welcome back. That was testimony from Samantha Whittaker. She's an ex-girlfriend of the defendant, Daniel Tate. Keep in mind, you only heard her voice. None of the ex-girlfriends that were associated with Daniel Tate wanted to be seen on camera. And still with me is D Pietro. David, we heard that testimony about how he would choke her with one hand, and sometimes she would have trouble breathing when they were involved in sexual encounters. And again, of course, one of the allegations is that Daniel Tate strangled, choked the victim in this case, Olivia McKay. But, you know, I said it earlier, I'll say it again, right? We're talking a sexual act, but there's no evidence to suggest Olivia in this case was was sexually assaulted. So how do we go forward with that to prove it to the jury?
Yeah, that's the tough part. It's based upon the other testimony from the co-defendant. It seems that it wasn't a sexual act. So how one is related to the other, it's a little bit of apples and oranges comparison. So I'm not sure what the probative value really is.
Right. So let's hear more testimony from an ex-girlfriend, Amanda Hanneman. She's, again, an ex-girlfriend of the defendant, Daniel Tate. Take a listen. So we just heard from another ex-girlfriend, Amanda Hanneman, in this case. Still with me, David D Pietro. David, she said she was choked so many times she can't really remember or give an exact number in this case. So I see what the prosecution is doing here. They're painting this picture that Daniel Tate is this guy that likes to choke women. And of course, we heard the defense say, oh, he's not big enough to do that. But you know as well as I do, it doesn't take a lot of pressure to choke someone. I don't care how big or how small you are. It doesn't take a lot of pressure. So I think I see what the defense is doing. They're painting this picture to say that this guy, this defendant on trial is who killed Olivia McKay. What say you?
Again, I think we go back to what you and I have said earlier. I think that they didn't really need this evidence. It's sort of unrelated to sexual acts. So it seems like they might have been trying to steal her car or do whatever. So I'm not sure really what the value is. And I didn't think the last testimony of the old girlfriend was, she made it like it was just a sex act less than 10 times. I mean, I'm not sure where it all goes.
Yeah, I think we're all baffled by why this was even allowed as testimony in this case. I don't think it adds any value to saying whether he did kill Olivia or he didn't. So let's hear from one more, the defendant's ex-girlfriend, Sarah Rantanen, and let's take a listen to what she had to say in court. Hey, welcome back. How about that bombshell in the courtroom? There is another ex of the defendant in this case, Sarah Rantanen, who testified in court that Daniel never mentioned anything about choking during sex. He never mentioned it to her, never tried it. And then, boom, the prosecution pulls out the police report, her signed affidavit, her signed statement, where she did indeed tell investigators that. Still with me, David D Pietro. David, what do you think about that bombshell?
It's never good when you have to go adverse against your own witnesses that you're calling. That just looks bad. I mean, you have to wonder, did he talk to her beforehand? How do you get bamboozled with that one? That's it, or did she just play him? And did he recover successfully? I don't know, but so you got questionable evidence in relationship to the crime. Now you got a witness who's denying it but admitting it. It didn't play out well.
Yeah, it looked really bad for the prosecution. And, you know, you've covered a lot of trials. I've been a witness in a trial. Typically, you have conversations about, your testimony prior to, and you go over your statements from, like, for instance, when I would go to trials for some of my arrests, they may have been 2 or 3 years before it goes to trial, but you get with the prosecutor, you go over your notes, you go over your statements to make sure everyone is on the same page, to make sure everything is truthful, to make sure nothing can come back to be misconstrued as being a lie at that time. So I don't know what really happened in this case. Very interesting. Didn't look good for the prosecution. We're going to take a quick break. Go refill your coffee. We got a lot more to cover here at the Law&Crime Network. Hey, that was testimony from Thomas Brown. Again, he's the uncle of 22-month-old Aiden McClendon, who was shot and killed in a drive-by shooting. He was not the intended target. Obviously, I believe Reginald Williams, who is a rival gang member of the shooters in this case, was the intended target. Thomas was actually there when the shooting occurred. This actually happened on Super Bowl Sunday. So while many people were out watching the game or having their Super Bowl parties, this family was dealing, unfortunately, with the death of little Aiden McClendon. Still with me is David D Pietro. David, you heard his testimony there, but I think the most interesting part of that testimony we just heard is I believe he said he couldn't identify who did the shooting. What do you think?
Right, yeah. So, I mean, obviously he needs to be called as a witness because he was there and witnessed this horrific tragedy. So I think he's essential as a witness, but obviously he's being truthful on I believe he's being truthful on what he saw. So But somebody's going to have to ID the shooter at the end of the day.
Right. David, let me ask you this. This is a very interesting trial. It's not like one that we've covered here or one that I've even been a part of. There's actually 2 juries in this case. Is that something that's common in the state of Florida? I know you're down in Florida. Is that something that's common when you have 2 defendants? Why wouldn't you just have 1 jury in this case?
The reason you have 2 juries when you have 2 separate defendants deals with when one makes a confession or a statement. Since you can't cross-examine the defendant because they have the right to remain silent, one of the co-defendants, the other co-defendant is prejudiced by that. So what the jury will actually leave when one jury will actually leave when the prosecution is presented the statements from the co-defendant who made the statements. So it has to do with the confrontation clause and a right to cross-examine the witness. Since you can't do it, and they want to try the defendants together, and you have to have 2 juries at that point, so that one will hear the statement and one won't.
Got it. And it definitely makes for a much longer trial than your typical trial. We want to take a listen to the investigator in this case that testified, Officer Christopher Poole with the Jacksonville Sheriff's Office. I believe he actually was on duty on that day. Let's take a listen to what he had to say. Hey, welcome back. We were listening to testimony from Officer Christopher Poole of the Jacksonville Sheriff's Office. He was discussing, he had got a tip from some confidential informant that some PCE members were up at Buffalo Wild Wings, which is a restaurant chain nationwide. And we heard testimony how he and the squad were getting ready to initiate a traffic stop. Still with me, defense attorney David D Pietro. David, let me ask this. My days, especially when I was working narcotics, anytime I would say I used a CI, of course, when you say the word confidential, that name is not supposed to come up in court. But the defense will always hammer back and say, well, what is your source? How do we know your source is reliable? So how does this officer introduce this from a CI standpoint, but yet make it credible to the jury?
I think that's where the prosecutor and the witness need to explain why having CIs and maintaining the confidentiality is so important. Because if that confidentiality is not important, CIs won't speak to police, which will inhibit investigations and cause more crime. So they just need to explain the public interest behind having confidential informants and keeping them confidential.
Right, and keep in mind this is a gang case, so anytime you're dealing with gangs, you definitely want to keep those witnesses as confidential as you can. There were a lot of gang members in this case that have testified that weren't on camera for that exact reason. So yeah, anytime you're dealing with street gangs, you definitely want to keep that information confidential. We're going to get back into the courtroom and hear more testimony from Officer Christopher Poole. Take a listen.